Please be seated. Good afternoon. This is the time set for oral argument in our cause number CV140199, Sullivan versus Pulte Home Corporation. We are recording today's proceedings, so when you step to the podium, please identify yourself. And each side will have 20 minutes for argument. Mr. Sullivan, as the appellant, you are responsible for watching the clock and reserving any of your 20 minutes for rebuttal that you might desire. We have read the briefs. We have conferenced the case prior to argument. So with those preliminaries out of the way, Mr. Sullivan, you may proceed.
Good afternoon. I'm Attorney John Sullivan. I represent myself and my wife Susan Sullivan as the plaintiff appellants in this matter. Pulte takes us back to Karstens versus City of Phoenix, where building inspectors failed negligently to find building code violations that led to unrepairable defects and caused the Karstens to tear down their home. The Karstens suffered economic harm. When that matter, I should say that the City of Phoenix defended on the basis that they had no duty to prevent economic harm. And when that matter reached this court, Division 1 framed the issue as whether the economic loss doctrine precludes tort recovery when the Karstens have alleged no physical injury or property damage resulting from construction defects. The court went on to hold that the economic loss rule bars a party from recovering economic damages in tort unless accompanied by physical harm, either in the form of personal injury or secondary property damage. Now, the Arizona Supreme Court did not review Karstens directly, and that was in 2003. However, in 2010, when the Arizona Supreme Court took up Flagstaff, they also brought up Karstens, and they specifically rejected the holding in Karstens. And this is what they said, quoting and citing Karstens. They said, "Some courts have stated that the economic loss doctrine bars a party from recovering economic damages in tort unless accompanied by physical harm. This formulation of the doctrine, however, is overly broad. In many contexts, tort recovery is available for solely pecuniary loss." Now, Pulte has another way of framing that. They've tried to weave in the restatement third, illustration 6, as a context to deny the Sullivan's recovery. But there are a number of problems with that. First and foremost, the restatement third is not the law in Arizona. The Arizona Supreme Court has adopted the restatement second, sections 323 and 324A. And those sections, if they were applied directly to Pulte's argument, also allow for economic recovery. This court last year in Steinberger versus McVeigh recognized that the Supreme Court had extended liability under the restatement second to include recovery for economic harm. Now,
while you're on the restatement point, what, if anything, do you make of the Arizona Supreme Court's reference to the draft restatement section 6.2 in the first Sullivan case?
I've given some thought to that, Judge, and I don't have a clear answer. Any answer I would give you would be speculation. It may very well be that they recognize that was a work in progress. Perhaps they didn't know what would develop from that as time passed. When the matter got back to the trial court, how it would be addressed. But in any event, I will be discussing the restatement third so that I might bring some clarity to that issue.
Mr. Sullivan, before you go on, could you give me the name again of Steinberger versus?
Steinberger versus McVeigh?
McVeigh, okay, thanks. Yeah.
Yes, Judge.
Yeah, okay.
Do you need the citation for that, Judge?
If you have it handy, that'd be great.
This is the case that keeps giving. Last week it came up in oral argument, the IndyMac one.
Remember? Oh, this is the IndyMac case? Never mind, Mr. Sullivan, I can find it.
All right.
I guess this case is popular right now, so.
It is.
Okay.
Well, anyway, Judge, the problem is that the restatement third relies on, and section 6 relies on an illustration that the author extracted from an Illinois case, Radarowitz versus Ollendorf. It's a 1982 Illinois Supreme Court case. And the author used that illustration by extracting part of the case as an illustration to what happens in the absence of a relationship. The author did not intend to describe what happens in the event that a duty arises from some other source. And support for that intention, I think, can be drawn from the case itself. If you look at Radarowitz versus Ollendorf, you'll find that the homeowners did recover economic loss, and they recovered it on two bases. They recovered it under the implied warranty of habitability, and they recovered it because of building code violations. Now, further support for the author's intention in drafting that illustration can be found in Section 1, Illustrations 1 and 2 of the Restatement Third. And 1 and 2 have a similar scenario where there are a plaintiff and a defendant who have no relationship, but the defendant has engaged in conduct that has caused economic harm to the plaintiff. And in those illustrations, the author of the restatement found that there was an ability to recover by the plaintiff on a policy basis. And I think that demonstrates that when the author extracted this example from Ollendorf, or Radarowitz versus Ollendorf, showing that there was an absence of a relationship, that now where there is an absence of a relationship but a policy reason to find liability, then it's all right for the plaintiff to recover. Further, if you look at Section 1, Comment D, you will see where the author talks about subsections 5 and 6 being a substitution for contract. Again, talking about a relationship between the parties. The author, in discussing Illustration 6 and Section 6, was not trying to address any other source of duty that may arise. Now, on a whole, the Restatement Second or the Restatement Third, I don't believe, apply to this case. The Sullivans aren't claiming that a duty is owed by Pulte to the Sullivans based on some form of relationship. We're claiming that the duty is owed as a matter of law, and that can be found under Arizona's construction laws, which are specifically in ARS 321154, and more specifically in the Arizona Administrative Code, the Registrar's Regulations. Under the state statute, the legislature has told contractors that they shall not depart from building codes, and they shall not violate rules of the registrar of contractors.
Mr. Sullivan, let me raise a concern about that argument, because I've thought about it a lot. The building codes might arguably establish a standard of care, but even if there is an argument about negligence per se or just plain old common law negligence, there has to be a duty. The court has to acknowledge or recognize as a fundamental issue that there is a duty. And I struggle here because the building code provision or two that you rely on and the general regulation, the registrar's regulation, is very general. And that basically would create a duty under all circumstances at all times. And I just wasn't persuaded that the building codes are a strong enough basis for recognition of a duty. And so assume for the second that, even though you may not agree with me, but let's say then if we don't look at the building codes, where else would we look to for a duty?
Well, I think if you don't look at the building code, then arguably it's difficult to find a duty. And I think what I would say to that, Judge, is that the duty of care and the standard of conduct, as I'm sure you realize, are two separate things. Mm-hmm. And I think what I'm trying to say is that the duty of care is defined by the state statute and by the Registrar of Contractors Administrative Regulation. That's the duty of care. The standard of conduct would then be found in the building code, notwithstanding the fact, of course, that the building code has both civil and criminal penalties attached to it. I think an argument could also be made that the building code standing on its own creates a duty of care. But I think that the legislature has spoken quite specifically. They've said that the contractor shall not depart from the building code and shall not violate rules of the Registrar of Contractors. And if the Registrar of Contractors then has rules and the building code then has a standard of conduct, that's where we find the duty of care. The duty of care is more specifically perhaps found in the Registrar of Contractors regulation that a contractor shall perform all work in a professional and workmanlike manner, and a contractor shall perform all work in accordance with any applicable building codes and professional industry standards. And I believe that's the duty of care. You then look, I think, at the building code and the industry standards to see what the standard of conduct is. And I believe therein lies the difference, Judge. I think the duty of care has been well defined by the legislature and by the Registrar of Contractors. Now, the restatement, any of the restatement second or restatement third, as I said, is built upon, I think, a relationship between the parties, at least with respect to the sections that I'm talking about. And as I said, I don't believe that what the Sullivans are alleging, in fact, I know the Sullivans aren't alleging that Pulte is violating a duty that arises of some sort of relationship. But the Arizona Supreme Court has used a very narrow interpretation of economic loss that I think causes the court to perhaps stop and think about the duty of care with respect to whether there's a duty to prevent economic loss. In both Flagstaff and Sullivan, the Arizona Supreme Court has narrowly defined economic loss. In Flagstaff, the Supreme Court said that economic loss, as we use the phrase, refers to pecuniary or commercial damage, including any decreased value or repair costs for a product or property that is itself the subject of a contract between the plaintiff and defendant, and consequential damages such as lost profits. And in Sullivan, the Arizona Supreme Court said, although some courts apply the doctrine to generally bar tort recovery for purely pecuniary losses, Arizona takes a narrower approach. In Arizona, the doctrine bars only the recovery of pecuniary or commercial damage, including any decreased value or repair costs for a product or property that is itself the subject of a contract between the plaintiff and defendant, and consequential damages such as lost profits. And that stands also in contrast to the Restatement Third's definition of economic loss. The Restatement Third adopts a very general and broad definition of economic loss. And what the Restatement Third says is that for purposes of this restatement, economic loss is pecuniary damage not arising from injury to the plaintiff's person or from physical harm to the plaintiff's property. And that's precisely what was rejected in Flagstaff. And so the economic loss that's talked about in the Restatement Third is not the same thing that the Arizona Supreme Court has talked about in their decisions. Now, if we take it one step further, even though I will say that I still think that there's a problem with applying either one of the restatements because I think they're based on a relationship, and at least in the sections I've talked about. But if we do take it one step further, perhaps take a more pragmatic approach and look at the rationales that traditionally hold for denying economic loss are missing in this case as well. The first is that there's respect for contract. That's one of the rationales. And in this case, there is no contract between Pulte and Sullivan. There's no relationship of any kind other than, of course, this case.
On that point, I think Pulte makes the following argument, that even though there is no direct contract between you and your wife and Pulte, if we were to recognize a duty, that could upend or upset the ordering of risks and responsibilities between Pulte and the original buyer, your seller. What's your response to that argument?
Well, Judge, I think perhaps what you're talking about is elevating the original purchaser to, or relegating the original purchaser to a lesser position than the Sullivans, and I think that's an illusion. And is that what you're getting at, Judge?
Well, that's one of my questions. I think I was really saying, for example, let's suppose as between Pulte and the original buyer here, they're in their contract, I'm just making this up for hypothetical, but in their contract, they had agreed that the house would be built in a certain way. Okay, you now buy the house, and can you then allege that the house has a construction defect because it was built in that way, but that was the way the original buyer wanted it built? So are you upending then by that type of argument the ordering of the risk and responsibilities between Pulte and the original buyer?
Well, I think first and foremost, Judge, and I'm not trying to evade your question,
yeah.
we don't know what, if any, contract existed between Pulte and the original homeowner. We've never seen a contract. We don't know what the terms are. Given that, Judge, I would say that if the original purchaser contracted for purchase as opposed to construction, there might be an issue there as well. But assuming that the original purchaser contracted for construction, if the home was built in conformance with the contract with the original purchaser, but nevertheless violated the building code, that condition of the contract is an unlawful condition.
Let's assume it didn't violate the building code.
If it doesn't violate the building code and it conforms to the contract, I don't think the Sullivans have a claim.
That
Judge.
wouldn't be it wouldn't then be a defect, is really, I think, what you're saying.
I don't think that would qualify as a defect.
Right, okay. So the really, again, we don't have a contract, I understand your point, but we wouldn't be, under that hypothetical, we wouldn't be upsetting the private ordering because that's what the person wanted, the original buyer wanted, that's what they got. And,
Right.
Yeah.
And I don't see that we're upsetting anything in any other respect either, Judge, because Pulte had a duty on day one to conform the construction both to the building code and to the professional standards. And so if they fail to do that, they violated their duty of care, and that's primarily our position, Judge.
Let me raise another question. I know that you have argued that the duty here, we can recognize the existence of a duty because of the building codes and the statutes and the like, but let's suppose we're not persuaded by that. In Richards versus Powercraft Homes, our Supreme Court had some very strong language as to why a subsequent purchaser of a home should be able to recover damages from the home builder for breach of the implied covenant. Now, its reasoning, you cited part of that, I think, in your briefing. Is the court's reasoning sufficient to recognize the duty based on public policy? So we don't even have to go with the building codes? Could we recognize the duty of care based on the underlying reasoning of the Supreme Court in saying, for example, builders hold themselves out to be skilled in the profession?
Well,
People don't know whether they're getting buying a latent defect or not. I mean, they just don't know.
I think that's been incorporated into the registrar's regulations about requiring the builder to meet professional standards. So if that regulation didn't exist, then that would be a different argument, but we're not making that argument today because we're relying upon the registrar's regulations that require the builder to do exactly that, Judge. And so I'm running out of time. If you don't mind, I'd like to save a couple of minutes, unless, of course, you have other questions.
Well, I think we'll give you a couple of extra minutes as well as the appellees. I'm actually interested in the answer to the question you thought Judge Norris was asking, which brings up Judge Gemmel's footnote 2 in the Sullivan decision about, isn't this an anomalous result that you're proposing, that a subsequent purchaser would have broader rights than the original purchaser? And the Supreme Court didn't directly address that issue, but it's a curious result.
Well, the original purchaser was presumably in a position to negotiate the position that they wanted. And if they weren't, perhaps there was a contract of adhesion. And in this particular scenario, perhaps there was. We have what now is, I understand, to be the largest home builder in the United States, probably preparing draft form contracts that are presented to a buyer on a take it or leave it basis. But
I'm missing the point where it relates to a latent defect. So what are you saying as to that point? Because as I read Judge Gemmel's footnote 2, we realize that application of this is back with the economic loss doctrine, but a seeming an anomaly, a home buyer in privity seeking recovery for purely economic losses may have fewer legal theories to assert than a subsequent purchaser. It just seems like we're fast forwarding to a different setting, but that you're asserting rights that would be superior to those of the original purchaser.
Well, we don't know if they're superior, Judge. We just have no idea what the relationship was, what the contract terms were between the original purchaser and the Sullivans or any other subsequent buyer. We just don't know what those terms were. It's an unknown, Judge.
Well, I guess my point is you would be allowed to recover purely economic loss, whereas the original homeowner couldn't, even though you did have a contract-based claim available, but for the statute of repose.
Well, the original purchaser may have reserved the right to sue outside the statute of repose. We don't know, Judge. And if they didn't, then they negotiated the position that they negotiated, and perhaps for compensated accordingly. We just don't know what they negotiated or what terms, what benefit or lack of benefit, or what their rights and responsibilities were of the parties under that contract. We're assuming a lot of things about the existence of that contract that just aren't here, Judge.
So the basis of the duty, as you say, is only the building code.
Well, the collection of construction laws that exist in Arizona, which incorporates the statutes, the registrar's regulations, and the city's building codes.
And you're not arguing that a public policy would establish the duty.
That is correct. The duty of care is established by public policy. Yes, Judge.
Wait,
Well, wait.
that you said the opposite to Judge Norris.
Yes.
No, the duty of care and the standard of conduct are two different things. What I'm saying is that the duty of care arises primarily through the statute and the registrar contractor's administrative code. The standard of conduct is more carefully found in the building code because the building codes specify the design, they specify the materials, and they specify the workmanship that's required to comply with the building code.
Yeah, just to be clear, and I don't mean to interrupt you, but because I listened carefully when Judge Norris pursued that line of questioning, and you disavowed that in this case you're claiming that Pulte's duty arose from public policy. You're claiming in this case that it arises from the statutes and the building codes and construction.
Oh, all right,
laws,
I
you said.
see what you're saying. Well, I guess what I'm saying is that I view the collection of construction laws as a part of the public policy. A separate part of public policy, of course, could be the common law. And I think there is an argument that could be made that under the
Could be,
common...
but that's not the argument you've made, correct?
No,
the one
that's
you're
not
pressing.
the argument that we've made, no, that's
Okay.
right.
I'm going to add 3 minutes for rebuttal for Mr. Sullivan, and so the appellees can have 23 minutes if you would like that extra time. So, thank you. And Mr. Richmond.
Good afternoon. Thank you, Your Honors. Stephen Richmond on behalf of Pulte Home Corporation. With me this afternoon is my partner, Ann Tiffin, as well as Area General Counsel for Pulte, Mr. Christopher Ward. My co-counsel, Professor Bublik, is unable to make oral argument today. She's got classes to teach at the University of Arizona. Your Honors, the issue in this case is narrow, straightforward, and direct. Does a home builder owe a duty of negligence to prevent economic loss to a subsequent buyer? The clear answer, both under Arizona law and the Restatement Third, liability for economic harm, which has now been adopted by the restatement, is no. Such a rule would create open-ended liability to an indeterminate number of parties, fourth, fifth, sixth.
Let me stop you on that, because I'm not sure I buy that argument. I'll
Okay.
tell you why. Now, here we take the well-pled allegations, factual allegations complaint as true. And the allegation is that this retaining wall doesn't have proper footings, doesn't have proper drainage and the like. But it was latent, so that it could not be discovered. Now, the original buyers presumably didn't discover it, so the Sullivans buy it, and they've discovered the latent defects, and they've sued you, or sued Pulte. So at this point, there is a plaintiff who has pursued the claim. And at that point, another plaintiff isn't going to pursue it because the defects are now discovered. They're no longer latent, so no one else is going to see it. This is a case, instead of a domino effect, which is really what you're getting at, this is really a case of transferred loss or transferred damage, because if the first buyer would have discovered it, it would have stopped there. They didn't discover it. The second buyer discovered it. It stops there. It's not at all indeterminate. It is not a domino. There's not this indeterminate mass of people. There's one buyer at one time on this claim.
Well, let me respond to your question, Judge. First of all, the restatement addresses this point head-on. The restatement does not adopt a transferred loss exception. The restatement's example in Section 6, the illustration 6 that it gives.
I understand the illustration, but when you look at the reasoning of the restatement, the reasoning of Section 1 and the reasoning of Section 6, it is because the authors of the restatement have a concern with what they call indiscriminate or uncertain liability. But the reality is that this is not a domino liability situation. This is transferred loss. I understand it. I've gone over the restatement. But it is their reasoning that they just have decided, the authors have decided that they are concerned about open-ended loss. But this is not that type of case.
Well, with all due respect, I think the restatement does address the issue, and what it does, there's two rationales behind the restatement rule of no general duty to prevent economic loss. One is the open-ended indeterminate liability. The second one is that the remedies are best managed by contracts, because we're talking about disappointed expectations.
But why? Our Supreme Court in Sullivan 1 has really already, in large part, taken that argument away from you, because it is said that the economic loss doctrine is not applicable to non-contracting parties in the construction defect situation.
That's correct. This is not a case of the economic loss doctrine. This is a case of what...
But all of every single argument raised in the answering brief as to why there shouldn't be a duty are all of those arguments are the same arguments that are raised, that Pulte raised in saying that the economic loss doctrine should apply. And the Supreme Court's rejected them in that context.
Well, certainly the Supreme Court rejected the argument that the existence of the contract-based remedy of the implied warranty was not sufficient to avoid application of the economic loss doctrine. Okay, that's true. But the Supreme Court also said, citing to approval with the restatement, in the restatement's exact description of the economic loss doctrine in favor, and also citing to the restatement, we think with approval that there may not be a duty.
I'll tell you, on that point, admittedly, I feel like we're Hansel and Gretel. There's a breadcrumb in the Sullivan decision. But that breadcrumb suggested that we need to, and it's also in the Flagstaff Affordable Housing, the breadcrumb is that we now have to wrestle with whether there is a duty. The court did not say, yes, there's a duty, and no, there's a duty. It pointed out that there is an issue as to whether there is a duty. That's the question we have.
That's correct. And let me try to answer the question about the way this restatement addresses the fact that there's no duty, even in the instance of the latent defect. If you look at comment C to section 6 of the restatement, of course, section 6 is the section that deals with the negligent performance of services, which is what we're really dealing with. And it says, and it's entitled Subsequent Purchasers of Property. The restatement does not recognize tort liability in that circumstance. Liability fails as a doctrinal matter because the defendant did not act for the purpose of providing a basis for reliance by the plaintiff. In other words,
it's an invited reliance point.
That's correct. And there is no intent on the fact of Pulte to build the home for some unknown purchaser downstream, nor did...
But here's my problem. Here's my fundamental problem. In the Richards case, which I recognize as a case involving the implied covenant the Supreme Court was very clear on the whole policy reasons why subsequent purchasers should be protected. You read that case. I know you know it.
Yes,
it talks about it at great length. Our Supreme Court establishes public policy. That is a public policy. How can we ignore that as an intermediate court and say, well, that's the public policy to protect subsequent home builders from latent defects that they have no way to discover, and say, but that policy, however, we're going to blind ourselves to the application of that policy in this context.
Okay, so let's go back to what the restatement says exactly that. The restatement says, continuing with the same comment, the denial of liability is supported by the policy stated in Section 1 because the buyer of the house has other ways to manage the risk of latent defects.
Aren't the other ways completely hypothetical? I mean, for example, the restatement says inspection. Well, if you inspect and the defect is discovered, it's not latent, so there's no liability. It's also saying, well, maybe they can protect by getting an assignment. Well, this is all really hypothetical. What we're dealing with is the public policy of protecting home buyers, whether original or subsequent, who do not have the capacity to determine whether their house has been appropriately and professionally built.
That's correct. And when you want to talk about Richards and you want to talk about what the restatement refers to as the plight of the home buyer, the restatement's not ignorant of that. What it says is, instead of creating a tort duty, which could have a big spillover effect, and I'd like to address that in a second, with numerous parties brought into lawsuit, expensive litigation that I submit would not be good for consumers, because it would in effect be, for the same pleading of the same underlying facts, give rise to an open-ended warranty, in effect, guaranteeing the home builder has built this thing right for 20, 30, or 40, or 50 years. But the restatement says, the question isn't whether the buyer's entitled to a remedy. The question is, what's that remedy? And it says the better remedy is implied warranty. That's what this state has given to subsequent purchasers.
No, I've asked this, and I won't continue to berate this, but
Okay.
the restatement is substantially grounded on the belief that this is not a transferred loss situation. And comment 1 to the, section 1 to the restatement basically says that the restatement should fall away when the underlying purposes are not effectuated. And here, I do not see domino effects at all. I think this is a transferred loss situation.
Okay, well, I'll tell you why I don't. First of all, with all due respect, clearly I believe the restatement disagrees with you because it's addressing just exactly this situation, and the example that Mr. Sullivan referred to, which is the illustration 6, the Roderowitz situation where the chimney is going to pull away from the wall and it is a latent defect, and the court says there is no liability in tort. There may be a liability in implied warranty, is exactly. So the restatement has addressed all these concerns, Your Honor, and come down on the side of there is no duty and these rights are best protected by implied warranty.
Let me ask you one other question, and then.
Okay, I was trying to answer.
I know,
Go
but
ahead.
let me ask you this. Okay. In Woodward, our Supreme Court sided with approval Cosmopolitan Homes, a Colorado case, which is also cited in the comments to the restatement. And in the Colorado case, the court held that a subsequent purchaser could sue for negligence for the home builder. Our Supreme Court in Woodward cited that case with approval. The case was mentioned also by our Supreme Court in Flagstaff Affordable Housing, and it again confirmed that Woodward had cited that case with approval. What do we make of that?
Oh, here's what we make of it. There are a number of states, Colorado is one, where they do not allow the implied warranty remedy to span the lack of privity. So the subsequent purchaser can't bring an implied warranty claim like he can in Arizona. So they allow the negligence claim. Okay, so these are closely related, I'll grant you. The question is, what's the better policy?
Well, and just on that point, as I understand everything along, please correct me if I'm wrong, but doesn't the implied warranty of habitability only exist for a particular period of time, and if that period is passed, then the subsequent purchaser is out of luck?
Well, the implied warranty of workmanship and habitability doesn't have a defined period of time, but it is subject to a statute of repose, which bars your claim after 8 years in Arizona. And Your Honor, that's...
Doesn't that limit the availability of the avenue?
And that's exactly right, it does. And that's because of the legislative policy of the state of Arizona. So to your point, Judge Norris, Richards v. Powercraft, which would have extended the implied warranties to some unknown period of time, was addressed by the expressed policy of the legislature to only in this state be 8 years, in some circumstances 9.
And now going to 6?
No, it's 8.
It's
That
still going to
statute,
be at 8?
it's 8.
Okay.
It's 8. Okay? So the original purchaser, this is the anomaly that Judge Downey had pointed out that Judge Gemmell was aware of. By giving a subsequent downstream purchaser, third, fourth, fifth purchaser, a negligence claim, you're giving these people greater rights than the original purchaser who had a contract with the home builder. Plus, what you're doing by the example you set, Judge Norris, is you're going to have extensive litigation. Let me give you an example. Everybody, let's say we're on the 5th purchaser. And you're going to say, well, was there an inspection? What was discovered? Was it fixed? Was it maintained? Every single purchaser in that chain is either a party or certainly a witness. So now you're going to have this plethora of litigation where every other purchaser involved is going to get dragged into the case. What did you do? What did you know? What did you negotiate?
There is no question that if there is a duty in my view, it makes this very difficult litigation. I don't disagree with that at all. I think the plaintiff would have a very hard time
Well,
the longer it goes on.
But more than, right, hard time, but think of the policy from the home builder. Think of what's going to do to the consumer. Home builders are now saying the quality of my construction, the economic risk that something has to be fixed because it's based on original construction lasts forever for any subsequent purchaser. And so if it's raised, geez, there was this latent defect with a retaining wall. Now the builder, as a practical matter, is going to have to go defend itself and try to find out who bought and sold the land, interview those witnesses, possibly bring people into the case, and we could be talking about 10, 15 years down the road. I dare say one of the policy reasons by the legislature in saying we're going to cut off implied warranty claims after 8 years is because they felt that was a reasonable period of time.
Hasn't the Supreme Court, though, in a sense, addressed the argument you raised when it's said in Sullivan that just because there is a statute of repose, and I'm paraphrasing broadly, basically that the statute of repose would bar the implied warranty claim does not mean the economic loss doctrine should apply to bar the tort claim?
Absolutely, but there's 2 points you have to take from that. Okay, I don't think you can have it both ways. If you're going to say the implied warranty, which started with spanning the lack of privity in Richards v. Powercraft Home, as you correctly point out, Judge Norris, you have to take it along with what the public policy by the legislature is as well. So the Supreme Court had a choice. I don't think the Supreme Court's intent in Sullivan, with all due respect, was we're going to allow a subsequent purchaser 5, 10, 15, 20 years down the road to have greater rights than an original purchaser and can bring all these suits for economic loss. Okay, what I think they were saying is we're not going to use the economic loss doctrine because we're adopting the economic loss doctrine that's in the third restatement that says you need a contract. And there's an absence of a contract with a subsequent purchaser. But what they did say, we're not sure there's a duty. And they left it up to you all and Judge Brain as to whether there is a duty. And again, you've got to look, I don't think this is in dispute. The restatement and Arizona law say there is no general duty to prevent economic loss.
Can I interrupt you? Because
Of course,
I
Judge
understood Mr. Sullivan's argument here today to be somewhat limited. He said that his argument in this litigation is that a duty arises from the construction statutes and the code provisions relating to construction. And he disavowed basing his argument, his duty argument, on the common law. So isn't some of the discussion we just had not really the argument he's making?
I agree that it is not, but I was trying to adjust Judge
So let's
Norris's
turn
question.
to the argument that he is making.
All right.
Tell us why the construction code provisions and statutes don't form the basis for a duty.
Sure. It's very simple. The building code, by its express terms, it has to be, in order for a statutory scheme to create a duty, the party injured has to be in the class of persons that the statute seeks to protect and has to be injured by the purpose of the statute. The building code, by its express purpose, says it's a general health and welfare statute. It's not for the protection of any particular class of person. Nor are the registrar contractor statutes. It's a licensing statutory scheme, which is not, it's not unusual in the sense that in Title 32, where the registrar statutes are found, there's licensing of all kinds of professions. And so those don't create a duty. They may, and I agree with Mr. Sullivan, they may under certain circumstances set a standard of care, but they don't create the duty in the first instance. Second, in the restatement, one of the exceptions, the something more that can allow a duty to recover for economic loss is professional malpractice. The restatement says doctors, lawyers, accountants, even insurance agents can have those heightened duties that are imposed by law. It specifically excludes contractors, and the court will recall in Flagstaff Affordable Housing, the court itself said architects don't have these special obligations because it treated architects just like contractors. So there's nothing in those statutes that rises to the level like you have in a criminal statute where there's bodily injury or death or property damage, like in Gibson v. Casey, the prescription drug case, and those types of cases that would allow the building code or the registrar contractor statutes to provide a source of duty. I'd like to just address why I don't think it's a transferred loss.
Okay.
Transferred loss, besides the fact that the restatement had
I hear you on that.
had
I
this
read
and
it.
it didn't adopt it,
Yeah,
okay?
yeah.
So, other than in the subrogation context, I don't know of any Arizona case that's adopted that. Here, there's not the transfer loss because the original purchaser didn't have a negligence claim to give to a subsequent purchaser.
No, I read that, you're referring to the argument you raised with the Dobbs Law Review article. But Dobbs, in his treatise on tort law, describes this precise situation and says this is not, I use the word domino, a domino situation. This is a transferred loss case.
And you know, you're right. I believe that that's what Professor Dobbs says. That article was written before the restatement was adopted, and they didn't go along with him on that. And I would say, again, that there's different rights here. You've got a implied warranty right that's going to run, but a negligence claim isn't the same because the original purchaser didn't have that. So it's not the same rights being transferred. And the transfer loss means, like in a subrogation context, the rights are parallel. You're giving a subsequent purchaser greater rights than the original purchaser. That, to me, that's just, with all due respect, defies logic and is not a course that this court should go. So for those reasons, I don't believe so. Finally, with respect to transfer loss, Judge Norris, look at what it does. It's going to require the courts to examine facts to create a duty. You're going to have to say, well, what did this party know? Is it the same? What's the damage? And now we're into factual issues that are at odds with the direction in Gibson v. Casey, that we don't look at facts to determine duty. The duty's a matter of law. So I don't think that makes, I think for those reasons, we don't really have an appropriate transfer loss exception, even if you could adopt for the second that the restatement deals with that. And I just want to make one more comment about the inspection issue. A homeowner can always have an inspection. So you could have a latent defect that manifests in year 5, and then you can have some other latent defect that manifests in year 20, but you can always have a home inspector check the home in any way, shape, or form. In other words, if you're concerned about the roof, have a roofer pull some roof tiles off.
But if a defect is truly latent, then by definition, isn't it not discoverable?
You're absolutely right, Judge Howe, but I'm trying to, maybe I made a leap of logic, and let me explain where I was coming from. What I'm saying is something that might be latent in the sense that a reasonable walk around the house or even just climbing on a ladder wouldn't reveal. If you're particularly concerned because you know this is a 15-year-old home and I have no knowledge that it's been re-roofed, I want to check the condition of the roof, you can have somebody pull some roof tiles off, okay, who's a qualified roofer to say, these are the areas where roofs are more likely to leak, where there's a budding, a chimney, or where there's the rake in the valley come into contact, and therefore make that not latent anymore, make it discovered by an inspection. There are also warranties available that protect homeowners. And this is what the restatement tells us. These are better ways to manage this risk than by creating an exception to the no general duty of economic loss, no general duty to prevent economic loss. And I would support here that that would not be a good result for consumers because, again, it would be requiring a home builder to give basically a warranty on construction for an open period of time. That's in effect what we'd be doing, and that would not be good at all. If there aren't any other questions, I'll. Okay, thank you.
Thank you.
Thank you again. Pulte has repeatedly referenced the restatement third, but given what I've heard here today, perhaps what you need to do is to look at the restatement second, which is actually the law in Arizona, and in particular 324A. Because if you look at 324A and you take into consideration that the Arizona Supreme Court has extended the restatement second to include liability for economic loss, what you'll see in 324A is that one who undertakes gratuitously or for consideration to render services to another, which he should recognize as necessary for the protection of a third person or his things, is subject to liability to the third person for the physical harm resulting from his failure to exercise reasonable care to protect his
Mr.
undertaking.
Sullivan, how do we square that I know what the restatement says, but how do we square that, because it relies so heavily on foreseeability for the establishment of a duty, with what our Supreme Court said in Gibson, which is you do not consider foreseeability in determining whether, as a matter of law, there should be a duty.
I understand, Judge.
And I've struggled with that.
And my answer to that, Judge, is that the duty of care and the standard of conduct are two different things. The duty of care is defined by the state legislature in 321154 and the registrar of contractors in the regulation, which is I've forgotten the number of it, but I believe it's R46108 or something along those lines. That defines the duty of care. And I don't think you need to look any further than that to find the duty of care. The harm that results from a breach of the duty of care is not what defines the duty of care. So in this case, what we're saying is that we have economic harm. There was physical damage, but it's to the property that is in controversy here. But I think if you look for the duty of care, you don't need to look any further than the statute and the regulations.
If we agree with Mr. Richmond that the statutes that you rely on are just too general, do you lose? There's no duty? Is that it?
I suppose so, Judge.
Okay.
But I would beg to differ that they're too general. I think that the building code is very specific. Design, the materials, the workmanship are all specified. If you've ever seen the code, it's quite extensive. And then also, Judge, there was talk about being in a better position than the original purchaser. If you look at this case, we originally brought claims for consumer fraud, 2 counts, and 2 counts of fraudulent concealment and breach of implied warranty. The implied warranty was knocked off because of the statute of repose. But we lost on the fraud claims because we weren't the original owner. So in that respect, how are we in an advantage over the original owner? The original owner had fraud claims against Pulte because of what they did. And we also recognize, Judge, and I'm running out of time, we have to prove that the defect originated with the builder. We realize that.
Okay.
Thank you both for your arguments. We will take this matter under advisement and issue a ruling in due course. At this time, the court stands adjourned. Thank you.